So, what are the main options for pre-RIA investors facing an I-829 denial?
So this is often a strategic issue. If you have an I-829 denied, one immediate thing you could do is file a motion to reopen or an appeal. There has to be reasons to do that, and that is assuming that the reasons why you got denied can be fixed, perhaps with more documentation. But that's not always possible. As we discussed earlier, not all project failures can be fixed by showing more documents. Sometimes failure to do certain compliance by the project is the end, and there's nothing that can be done about it already at this point. Nonetheless, even if you don't have merit, necessarily legal merit, to file an appeal, sometimes it might be worth to do so just to buy yourself extra time, because another option for people who have 829 denials is to pursue what's called cancellation of removal. And cancellation of removal is after you got your I-829 denied, at some point, inevitably, USCIS will send you a notice to appear in immigration court. You're going to be placed in removal proceedings. And cancellation of removal is one of the possible defenses to removal on the basis of an I-829 denial. But to pursue that, there are certain time requirements that need to be have satisfied. So you need to be a permanent resident, conditional resident, for at least 5 full years, and you need to have been in the U.S. with other status prior to your permanent resident status for at least 2 years, so 7 years total. So sometimes filing an appeal, even though we know it won't necessarily help, sometimes it's useful because it will help that time to keep running before you get placed into removal proceedings. So that's why those two possible things are related to one another: motions to reopen and pursuing cancellation of removal in immigration court. So if you're facing a 829 denial, you should talk to an attorney as soon as possible, because time really is of the essence in that situation. And in some cases, when a person got I-829 denied and has no relief available to them, is not eligible for cancellation, is not eligible for any appeals, etc., the only other option really is to do a new EB-5 investment in a new post-RIA rural project. That's probably the best way to go if you have no relief, because rural projects are prioritized by USCIS. They are current in the visa bulletin for some time, and you will be able to get them adjudicated fairly quickly in many cases. So since being placed into removal proceedings is a very time-sensitive matter, if you're going to make a new investment, it's important to pick one that will help you in getting the relief in a timely manner.